With that, I'd like to introduce Professor Samuelson. She is the Richard M. Sherman Distinguished Professor of Law and Information, a pioneer of digital copyright law, intellectual property, cyber law, and information policy. And she is a joint appointment since 1996 in the Law School and the School of Information. So please join me in welcoming her today.
So thanks for coming. I really appreciate having an audience for something like this. So hello. And thanks also to the CITRIS folks for inviting me. I have been looking forward to having this opportunity to talk to you about what has become my favorite subject lately, the Google Books settlement. The idea of thinking about the Google Books settlement as copyright reform actually came to me first through the offices of Dan Clancy, the chief engineer at that time for the Google Books Search project. He came to Berkeley and we sat at Strata Cafe, and he said, "Pam, you got to support the settlement agreement because it's really important to be able to get access to these out-of-print books, particularly the orphan books, and the only way we're going to be able to free them up is through the settlement. Congress is broken, and so the orphan works legislation that has been pending hasn't passed. This is the way to do it." And I thought, well, that's actually a really interesting gambit. It obviously showed some insight because he would know that I'm actually a fan of the idea of some copyright reform, and I have concerns about what Congress does about copyright. But I sort of felt, when I thought about it, like, well, there's one part of our government that's broken, so let's break another branch of government, namely the court system, by approving this particular settlement. So I've had qualms about it ever since the opening gambit, but it actually made me think about these issues and about the settlement in a somewhat different way. And so most of what I'm going to do today is talk to you about some respects in which the Google Books settlement, if approved, would achieve results that were tantamount to legislation, and then ask ourselves, you know, is that a good thing or a bad thing? I'm going to offer you some reasons why maybe it's not such a good thing, but this is obviously something that many of us would have differences of opinion about. But before I do that, I want to talk a little bit about the settlement because I know the settlement really well, and I know a couple of people in the audience know it well, but most people kind of have only a vague idea about it. So what I'm going to do is talk about talk about some ways in which, right, the settlement addresses some things that are dysfunctional about copyright law today, and that's part of the reason why it would achieve a measure of copyright reform. So let's get started. And then I want to talk about, well, what happens if the settlement isn't approved? Are there ways to get access to these books anyway? So very quickly, you probably all use Google Book Search regularly, but it's worth knowing that Google started the project in 2004 by making arrangements with many university libraries, particularly public university libraries, to scan books from their collections. So University of Michigan has made 7.8 million, their entire collection, available to Google for scanning. The University of California has committed to making 2.5 million books available for scanning, and that includes in-copyright books. The libraries, when they make a partnering agreement with Google, get back a digital copy of the books from their collection that Google scans. So the idea is only Google would have the corpus as a whole, but University of Michigan, for example, will get a corpus of the books that are scanned from their library. And this was a kind of a bold move on Google's part and on the library's part, but Google basically said, look, we're going to scan the books for the purposes of indexing them and making snippets available. We think that's fair use, and we're prepared to defend that in court. And so it also is the case that Google makes a lot of what they call non-display uses of the books in the corpus to refine their search technologies, to develop better automated translation tools and the like. And at least some folks think that the main reason that Google scanned the books was not to make the contents available to the public, but rather to make these non-display uses that would improve their search technologies. In 2005, the Authors Guild and 3 of the author members of the Guild brought a lawsuit in the Southern District of New York, suing Google for copyright infringement, saying that the scanning of the books and providing snippets on a systematic basis was not fair use, but was copyright infringement. The Guild brought the lawsuit on behalf of all the owners of rights in books that were scanned from the University of Michigan library. Google responded by saying that this was fair use. Another of its defenses is it's not clear that there's really a class action. There's a class that can be certified because of some differences in interests among members of the class of rights holders. Academic authors, for example, are more likely to think that scanning for the purpose of indexing is fair use. And if there is a different legal perspective among members of the class, then that's a reason why classes can be unable to be certified. There was a separate lawsuit by 5 of the trade publishers, including McGraw-Hill and Macmillan, against Google, alleging virtually the same things, but it was not a class action. About 6 months into the lawsuit, the parties sat down and decided to negotiate a settlement. They spent 2.5 years negotiating a very complex settlement agreement, which is available on the internet if you're interested in it. And they announced the settlement in 2008. The last time that Google was making information about the size of the corpus available was in February of 2010. At that time, they said that there were more than 12 million books in the corpus. About 2 million were in the public domain. About 2 million were in print and were part of the Google Partner Program, which is separate from the library program that I'm mainly going to be talking about. And then about 8 million of the books are out of print, and some proportion of that, some people think it's 20%, some people think it's much more above 50%, but we don't know yet, are likely to be what are called orphans. That is to say, books that if you spent time trying to track down the rights holder and get permission, that you, after a reasonably diligent search, you wouldn't be able to figure out and get permission from those people. And so there's kind of no rights holder there to get permission from. And right now, it's a risky thing to make orphan books available, even if you know a book is an orphan. Okay, the core of the settlement is that Google will provide $45 million to compensate owners of rights in books that were scanned as of May 2009. This includes $60 per book and $15 per insert. Inserts are things like forwards and chapters of books in kind of edited volumes and the like. And then another $34.5 million is going to be set aside to create a new collecting society called the Book Rights Registry. And then you sign up with the Book Rights Registry, you get your $60 per book, and then you share in any new revenues that the Book Rights Registry gets from Google. So that the commercialization efforts that I'm going to talk about in a minute, 67% of the revenues are going to be thrown over the wall to the Book Rights Registry. The BRR will then be responsible for giving out the money to the appropriate rights holders. And then $45.5 million goes to the class action lawyers who negotiated the case, which I think it's a little ironic that they're getting more money than all of the authors of all the books in copyright in the world. Okay, that's kind of like breathtaking to me, but that's another thing. And then Google, among other things, gets a license to scan all the books covered by the settlement and make non-display uses of them. Under the settlement, Google gets to make what they call display uses of all out-of-print books, unless the right holder comes forward and says, no, I don't want you to commercialize it, or no, I only want you to make this display use and not that. But display uses means for all of the out-of-print books, up to 20% of the contents of the books could be displayed in response to search queries, and the whole of these out-of-print books could be available through an institutional subscription of a compilation of the books through public access terminals at public libraries and at subscribers to the service, such as universities. Google will generate 4 types of revenues from the Google Books settlement model. One is that there'll be revenues that will be generated by running ads next to queries. There will also be selling books to individual people in the cloud. The ISD, the institutional subscription database fees, will probably be where the big money is. But there will also be printout fees for every page that's printed from an out-of-print book from the corpus at public access terminals in libraries and the like. The original settlement was announced, as I said, in October of 2008. The fairness hearing on this case was held in February of this year. We have all been waiting for a long time for the judge to issue a ruling about whether to approve the settlement or not, and he has not yet done that. It's worth knowing that the Department of Justice and the governments of France and Germany have come out against the settlement. There are the overwhelming majority of the approximately 500 filings with the judge about the case are objecting to it or opposing it in one way or another. And I'm going to talk about the DOJ's reasons for being against the settlement as I go through the talk. Now, part of what's interesting to me about the settlement and about the Google Books thing in the first place is that there's some dysfunctions of the law in the United States that in some sense contributed to the settlement and then led to, or contributed to Google's willingness to undertake this in the first place and then its interest in settling the case. I'm not going to talk too much about it. This is the kind of thing law professors love. But the Supreme Court has issued a bunch of rulings in cases interpreting the 11th Amendment to the U.S. Constitution. And under the current interpretation, state-related institutions, such as state universities, are immune from any damage liability whatsoever, which means that University of California, University of Michigan, University of Texas, University of Wisconsin could supply Google with the books without worrying at all about any kind of financial liability for copyright infringement or for contributory infringement. And so the overwhelming majority of in-copyright books that are not part of the partner program are in fact being scanned from the public university libraries, because the worst thing that happens is that they have to stop using the library digital copy that they get back from Google if the case goes bad. But there are also some library and archival exceptions to copyright law that are really not kind of fine-tuned for the digital age, right? Libraries really probably ought to be able to scan books for the purposes of preservation, but the current copyright law makes that kind of digitization activity on more than a kind of, gee, this book is about to fall apart basis, a pretty risky thing to do. So one of the ways that the settlement achieves copyright reform is it basically allows all the libraries to have access to these library digital copies and to make some pretty significant uses of them, things that maybe a wise Congress, if there was such a thing, might be willing to do, but hasn't done so far. Another thing that the Google Books settlement does, and this is probably the most important thing that it does, is that it provides a way to get access to and provide public access to orphan works, these books whose rights holders cannot be found through a reasonably diligent search. Mainly, the reason that we have this orphan works problem today is because Congress has extended the term of copyright time and time again. So most of the books, all books published before 1953 should be in the public domain by now, but a lot of them aren't because of these copyright term extensions. And most books published before 1978 also should be in the public domain because most of the time, if the book is not still commercially viable, then there wasn't any point in renewing for a second 28-year term. And so a lot of these books really should be in the public domain. Also, there's reason to think that somewhere between 60 and 80% of the books published between 1923 and 1963 are in fact in the public domain for failure to renew their copyright claims. We just don't know which ones are which. And because the Copyright Office has not automated those records, we can't tell. And so there's a whole bunch of books that ought to be in the public domain that are actually in the public domain. We just don't know which ones they are. There are also some what I'm calling procedural dysfunctions that contributed to the Google Books matter, and especially the settlement. You got to say Google has got cojones here because they were facing a potential liability, according to one of the people who calculated the statutory damage potential exposure at $3.6 trillion. Now, I would have said $1.2 trillion, but hey, what's $1 trillion one way or the other? Because statutory damages are available per work up to $150,000, if it's a willful infringement, that actually adds up to a lot of money. So Google's willingness to undertake this project, given the potential liability for statutory damages, was kind of breathtaking. But you can understand how it would give them also a reason to want to settle the case to avoid that kind of exposure. And I think I'm going to skip the registration point, except that the deal was cut at a time when the Second Circuit Court of Appeals decided that rights holders who hadn't yet registered their claim of copyright with the U.S. Copyright Office were ineligible to participate in a class action settlement. So the settlement really sort of focused on those folks that have registered with the U.S. Copyright Office or are from a couple of other countries, which, if you're interested, I'll tell you about. Another thing, and actually a really important thing about the settlement, is that there's a huge debate right now about who owns the rights to allow the digitization and sale of books in digital form, or e-books. There's a case, Random House versus Rosetta, that interpreted a common grant in trade books contracts. The right to publish the work in book form essentially was a limited grant. It basically only covered the right to print the books and sell the print books, not to make e-books. And so authors then who had authorized Rosetta for making e-books available were allowed to do that. But publishers are really, really not convinced by that decision. And so one of the most important aspects of the case of the settlement is Attachment A, which is essentially was something that was negotiated between the authors and the publishers. Not Google just doesn't have a skin in this particular game. And it's basically decided, kind of made a compromise. So the authors think that they should get 100% and the publishers think they should get 100%. But the compromise that was reached for all books that were published after 1987, there's a 50-50 split between the authors and publishers, because by then there was at least a possibility of some digital book market potentially in contemplation. Before that, authors get a bigger split because this was not in contemplation. Many books, actually, book contracts have reversion policies, so if the book goes out of print, the author can get it back, but there's a kind of formal procedure that needs to happen, but it's not standardized, so the attachment also tries to deal with that particular problem. Now, the pragmatic arguments in support of this settlement are really strong. One of the things that's very clear is that a lot more books would be a lot more widely available to all of us, especially university communities, would benefit by being able to get access to the corpus of books for the purpose of engaging in what the settlement calls non-consumptive research. It also is going to get some money to the rights holders, and that's actually a good thing. Copyright likes that. And at least initially, there's a reason to be optimistic that Google will price both the books and also will price the ISD, the Institutional Subscription Database, at reasonable levels. And of course, there were lots of compromises that are embodied in the settlement. And if you kind of like ask, well, would you have been able to get a better deal in Congress than the settlement? You sort of say, well, maybe not. So you could say, well, that's an argument in favor of the settlement then, at least from a pragmatic standpoint. I've spent some time in the last year talking about some risks that I think are real. I think over time, the prices of the institutional subscriptions will rise to very high levels, and that universities and public libraries will find it difficult to be able to do without it, and yet difficult to pay for it too. There are not any meaningful privacy protections built in. Google says, don't worry, we'll do this, but it's like, I'd like to see it in the agreement, thank you. And there are some serious questions, really from a kind of democratic theory standpoint, about whether it's a proper use of the class action procedure. But if you like the settlement terms, the idea that you should go ahead and just, ignore the issues of what you can do through a class action settlement, just trivial, whatever. Okay, so I'm not going to talk about all of the aspects in which the settlement is like legislation, but usually to get a license to scan in copyright books and maybe even to make non-display uses of them, you'd have to get a license from Congress because they're the only ones who enact copyright laws. Google also, under the settlement, will get the right to commercialize all of these out-of-print books, including all of the orphans. It solves the ebook ownership problem, the attachment A thing I was just talking about for a minute ago. It gives licenses also to libraries to make some uses of their LDCs, the library digital copies, that are far broader than the rights that are for libraries in the copyright statute. There's some safe harbors, and print disabled people will get more access. There's also a kind of special set of releases from liability and damage limitations and compulsory arbitration. So they're setting up their own private, essentially dispute adjudication procedure that essentially will limit their liability, and no statutory damages could be awarded against them because statutory damages suck. But I want to talk just a little bit about especially the orphan works kind of problem. Now, part of what's really clever about the settlement is that it sort of says, look, there are all these books that are, let's say, millions and millions of out-of-print books out there. And, Google's going to try to scan them all. And we don't know which of those out-of-print books, in fact, would turn out to be commercially valuable today. Some of them would be, some of them wouldn't be. But it's really, really expensive to try to track down the rights holders for each book. So let's just scan all the books. And right now, none of these books are making any revenues. So if we start churning the revenue model, right, commercialize them, we'll get a lot of money, and then we'll start looking for the people whose books are generating money, and we'll give them a check, and then they'll sign up for the book rights registry, and then everything will be perfect. And so, yeah, there will be a few books that people won't sign up for, but the way to find out which books are really valuable is to go ahead and commercialize all of them. And then if the rights holder doesn't want it, they can come forward and say, don't do this. But this is, it's a very, very clever kind of idea. And the idea that as long as there's money waiting for a rights holder, that they'll all want to show up and sign up for the book rights registry is part of the reason why the Authors Guild representatives say, oh, orphan works is a myth. I don't think orphan works is a myth. The Financial Times estimated that somewhere between roughly 3 and 5 million of the 32 million books in copyright in libraries in the United States are going to prove to be orphans. My intuition is that the number is going to be higher than that. These, let's say, 4 million books are going to make up a pretty substantial part of the institutional subscription database, which universities will be charged for. Google will have a de facto monopoly over those orphans and the collection of others, because the Book Rights Registry can't license third parties except with permission, and only people that signed up with them are able to give that kind of permission. And under the settlement, the orphan books will be priced at profit-maximizing rates through the end of their copyright, even though there's no rights holder that's kind of like wants the money. And so it's interesting to see that there's an interesting issue. Well, what do you do with the money? Well, in the initial draft of the settlement, Google would have provided all of these funds for these unclaimed books to the Book Rights Registry, and after 5 years, all the registered rights holders would get payments from the rights holders whose books who hadn't showed up, right? So if, let's say, $50 million, that's a lot, maybe $10 million, $20 million, let's say a big amount of money is collected for people whose books have not yet been claimed, well, it would all get paid to the people who had shown up and registered their books, and so they'd get a windfall for books that they didn't own any rights in. And the Department of Justice actually said this is a blatant conflict of interest within the class, because the people who register don't have much incentive to look for the people who don't register if they're going to get money at the end if the rights holders don't show up. So after DOJ came out against the settlement for that reason, a second amendment to the settlement agreement kind of envisioned a new way of dealing with these unclaimed funds. And so they were sort of imagining that there were going to be an unclaimed work fiduciary who's going to take care of this. And after 10 years now, instead of just 5, instead of reducing the price of the institutional subscription, the idea is that that the unclaimed work fiduciary will give the money away to literacy charities. It's like, well, yeah, that's one way of dealing with it, but maybe not the best. Anyway, I'm not going to talk too much about it. I have a lot of problems with this particular solution, but basically the problem is that this is not what this is what Congress should be doing, not what a set of litigating parties should be doing. It's inconceivable that Congress would give a license to all the orphan books just to one company, namely Google. And so one of the things that would be a benefit about doing this through legislation is that other entities, including the Internet Archive, would be able to make orphan books available too. And the legislation that has been pending before Congress in a couple of the sessions in the last decade about orphan books have really said that, look, if you can't find the owner of the rights in a book, then the book should be available on an open access free basis, right? So anybody should be able to freely reuse it because there's no rights holder who needs to get compensated for the use. And so let's just allow free use of these things. And it seems to me that's the right solution from a societal standpoint. And this has very important implications for the pricing of the institutional subscription, right? If all of the books that are orphans are able to be available on an open access basis, then the prices of the ISDs will fall because probably at least half, if not more, of the ISD will be made up of orphan books. But under the escrow regime that the settlement agreement would put in place, the ISD prices would probably rise substantially over time because Google can't set the ISD price by itself. It has to do it in connection with the Book Rights Registry. and that registry will be made up of a board of people representing the trade publishers and the Authors Guild type people, and they will be pressing for ever higher prices for this. It's just logical that they would. Attachment A is also a kind of thing that Congress could do. One of the things the Department of Justice noticed is that you know, for everybody, who knows who owns the ebook rights, right? It would be foolish for anybody who wanted to digitize books to try to get both the author and the publisher to agree, because then you'd have to pay twice. But if you don't know who is the rights owner for these books, then you kind of have to do that in order to be safe. Whereas attachment A gives Google a huge advantage because it resolves that, right? Google just throws the money over the wall, and then it's up to the book rights register to figure out what the revenue split between the authors and the publishers ought to be. And there's compulsory arbitration if there's disputes about that. And so one of the things that then is of concern is that, look, this issue was not in litigation in the case against Google, so maybe it's beyond what the litigation really should be able to do. And that's actually the issue to which I want to turn now, and I'll try to do this real fast so that we can get some questions. So the Department of Justice basically said, look, there are lots of good things that the settlement aims to achieve, and here is a list of them. But the DOJ ultimately concluded that the settlement was, as they called it, a bridge too far. And here's the reason. If you go back and look at what was actually the issue in litigation, it was whether or not scanning books for the purpose of making indexes to make snippets available, is that fair use or copyright infringement? That's the fundamental issue in the case. And all of the things that are involved in attachment A and the commercialization regimes that are envisioned in the settlement agreement and all of the other dimensions that I've been talking about, they weren't in litigation, right? This was not part of what the case is. So before the judge in February, the DOJ representative said, it is the duty of class counsel to litigate the claims they actually brought or to settle those claims. And this doesn't settle those claims. It basically takes the opportunity of a litigation on one issue, essentially to remake the market for books for the next century. And that is too far beyond what was actually in litigation in the case to make it an appropriate thing to resolve a class action lawsuit through this mechanism. So that's essentially what they were arguing. The DOJ representative said it's for the Congress, not for the private litigants to address and resolve the orphan works issues. And DOJ came out really very strongly saying, Judge, you lack the power to approve a settlement this broad. It raises some pretty fundamental questions, ones that I'm grappling with. It's not my expertise, this class action stuff, but you have to learn what you have to learn. And there isn't any sort of clear criteria yet for determining when is a matter legislative in nature or okay to kind of resolve through class action settlements. It's clear that sometimes matters start out in litigation and then Congress basically acts to address the thing, so there's certainly some overlap there. But one of the things that I've been trying to do is kind of articulate factors that would suggest that some things are more suitable for legislation than class action lawsuits and settlements. And so these are my criteria, the larger number of people in the class. Here we're talking about millions. The last estimate that I saw that Google folks promulgated about how many books there are in the world that they want to scan was 129 million. So that's a lot of books and lots of rights holders out there. The greater diversity of their interests, and in my paper I talk about a number of ways in which there is kind of inter-class kind of divergence of interests. And the broader the settlement is as compared with the issue in litigation, the more comprehensive its impact on the future, and the more there'll be spillover effects on third parties, such as all of us. seem to me to be things that point in the direction of this is something that Congress should do, not private parties. I think another thing that approval of this settlement would mean is that orphan works legislation would be less likely. Google will tell you, oh no, it's going to make it more likely, but if it did happen, then it would be skewed to adopting the kind of escrow model rather than the free use model that I think is the more appropriate way to treat orphan works. And I worry also that there are going to be a lot more copyright class actions in order to, if Congress is basically broken and you want to solve some problem, then you bring a lawsuit on one small issue and then you kind of settle it in order to sort of resolve that. I also argued to the judge when I appeared before the court that Google can use an approval of the settlement as leverage with rights holders of other types of works, right? I said, who's next, right? Google's aspiration is to make all of the world's information accessible, etc. So since all the world's information is not contained in books, who's next? And it seems to me that that would be an unfair kind of leverage. And then so the larger question is, well, if you can achieve essentially quasi-legislative reform through class action, why have a legislature at all? Is this the end of our democracy? You could say, well, they're self-destructing anyway, so who cares? But I still think there's some reason to be hopeful. The Department of Justice made a suggestion for an alternative way to settle the lawsuit. One is to have Google continue to pay, as the settlement now would do, $60 for scanning books in the past. But instead of having this, all of the books be covered by the license, to have an opt-in regime for the commercialization part of the Google books. Google has said this would eviscerate the settlement and that there will be no settlement if it's an opt-in instead of an opt-out regime. But, it's hard to know whether they'll become more receptive to that if the judge disapproves it. Of course, another possibility is that they go back into litigation, and I think Google would probably win the fair use defense, but more likely the Authors Guild would not be able to get a certification of the class. If they can't get a certification of the class, then it's not worth their while to bring the lawsuit, because you only get big money if you can get a class certified. I'm working actually with some folks now to try to develop an orphan books legislation package that would allow some digitization by Google and by others. And I'm also working with some university library folks to think about how we can develop initiatives to promote open access to out-of-print scholarly books. It seems to me that's something that we can do, whether the settlement is approved or not, and would be worthwhile. So that's what I wanted to talk to you about.
Questions? Yeah, please use a mic.
Hi. Your argument about the effect on third parties sort of cuts both ways, I think, because since Congress is only interested in protecting the rights of rich people, it's really hard to imagine any legislation that would protect the interests of the public, even to the extent that the Google settlement does. So what's your strategy for getting Congress not to support the rights of rich people?
So that's a pretty cynical statement. And I'll say that, that the House of Representatives has passed orphan works legislation, and there's actually a lot of support for orphan works legislation across the board. And so the big obstacle to orphan works legislation in the past couple of years when it was introduced into Congress was from photographers. I can understand that photographers feel more vulnerable than others because copies of photographs often don't bear the copyright notices that books do. And so it's, if you kind of go out, how do you search for the photographer who took this particular photo if there's not identifying information? They felt that they were too vulnerable. So I'm going to say that if we could narrow the legislation to an orphan books bill, that there's reason to be optimistic that in fact it could pass, and that would be something that already has partly happened. That is, one of the houses of Congress was willing to do it. And while I have to say, Congress has done a number of things in the copyright realm of which I am critical, they've also sometimes passed legislation that's been beneficial for the public. So the TEACH Act that was passed during the past decade is one which allows nonprofit classroom, essentially, uses that would otherwise infringe to engage in kind of teaching activities. So I'm not persuaded that there's no chance that some benefits would come about. And in some sense, Google's kind of changed the game, right? So there is right now a particular provision in the copyright statute, also enacted in the last 12 years, that allows some making available for print-disabled people Braille editions of books where the publisher hasn't made that available. I think that the settlement makes a bigger commitment to print-disabled works being available, and I can imagine that the bill that addressed some of these issues would have a broader, more GBS-like provision for print-disabled people. And I think there's also been some momentum building for expanding the library exceptions to make it more suitable for the digital age. And again, the Google Books settlement, in some sense, reflects a kind of compromise on the part of the Publishers and Authors Guild that non-consumptive research, right? So you have this big corpus of books, and you want to try to develop search algorithms, or you want to find all the works that discuss a particular philosopher. Google negotiated for that with the Authors Guild and the publishers, and so maybe there's some opening there that the settlement creates a kind of a model for some uses that actually should be permitted that would be beneficial to the public and beneficial for education. So, maybe that's all we're optimistic, but something.
Yeah, hi. I'm under the assumption that actually spreading this kind of open information, scanning the books, making them available to the public, is absolutely critical to the spread of information. But how would you propose that this be done? Instead, if companies are allowed to come in and or Congress is allowed to come in and kind of like promote this free spread of information.
Well, my own preferred solution, right, if I had my magic wand, I would say that either a consortium of leading research libraries or the Library of Congress should essentially kind of make a commitment to creation of a national digital library that would be available to us all. And especially for the out-of-print books, maybe you only let some small parts available until the work is an orphan or something like that. But it seems to me that a lot of the books that especially people in the research communities care about are books written by scholars for scholars. And it seems to me that if we can mobilize the community of scholars to essentially say, I want to make my books available on an open access basis, we can create a national digital library of those without too much difficulty, frankly. So that's kind of where I'm kind of heading with some of that.
Okay, I think we have time for one more question. So,
I've heard the proposal made that essentially goes this way. we gave $60 billion to General Motors and Chrysler to bail out failing companies. Let's give $5 billion to Google, say thanks very much, and nationalize the books. Make the National Digital Library. They made their money, the publishers get some money, and we're done. What do you think of that possibility? Better use of my tax dollars than TARP and GM.
It's for the posterity and the website and all that.
So as one of those authors that you're talking about, I actually put my book online. I kept the digital right. Addison Wesley owns the printed matter right. But there's the whole thing about artistic right, and it should be up to the author who creates the work to decide where it goes. And that's one thing that bothers me. In the U.S., we're more just based on economic rights. But I think we, as a society, as a global society, have to worry about the artistic rights of the author and the people who create the work. So I think that's one thing that seems to be missing a lot in these negotiations.
Well, it's certainly one of the bases that is to say the sort of concern that authors should be able to make choices about what happens with their work. That's been the basis of many of the author objections to the Google Book settlement, because it operates on a, yeah, you'll have choice, but you have to show up and you have to sign up and you have to like say no, and we're going to do it without your permission otherwise because it's too expensive to clear rights on a book-by-book basis. And I think for the purpose of scanning books to make snippets available, in fact, the transaction cost argument for doing that is pretty good. And Google, as I said, I think had a fair use defense for the snippet providing, because it was providing links to libraries from which you could check the book out, or bookstores from which you could buy the book. And so a number of authors were favorably disposed toward the snippet providing thing, unlike the Authors Guild folks, because it was, right, if you're searching for something on Lithuanian carpets, and there's a book that you wrote about Lithuanian carpets that comes up, all of a sudden a reader that you might not otherwise have had will actually get access to your book, and isn't that great? And maybe they'll buy the book, and that seems to me to be good too. To the question about $5 billion to nationalize it, that would actually be a pretty good return on investment for Google. You know, I can imagine a set of circumstances that would play out to make that kind of possibility attractive. But in the current environment, political environment, I don't see the marshaling of political will, and I think that the National Digital Library initiative that some of the leading librarians are working on is a more pragmatic thing to do at the moment. And maybe that builds toward a larger initiative once we kind of prove how important access to these books really are. Okay, thanks very much.
Thank you.